so that you make it a high risk, no gain business, nothing is going to happen. So Article 14, right to equality, is violated because the common man, corruption at every level, whether big or small, is bad. It's an equal crime. But it is a bigger crime, more relevant for sentencing, when it is of a higher magnitude committed by a person who does it, who has even luxuries, and he does it just because of greed, nothing more. But he goes scot-free. So Article 14 is violated. Ultimately, it deprives people of that money which would be available for development and therefore of necessities. So Article 21 is violated. The Supreme Court, under Article 32, has a constitutional obligation to protect and enforce the human rights of even a single individual if and when approached under Article 32. That Article 32 was described by Dr. Ambedkar as the soul of the Constitution. And our Constitution, the framers of the Constitution, did not rest content only with making it a constitutional remedy, a fundamental right under Article 32, but also enacted Article 142 so that the Supreme Court is empowered to make any order or pass any decree, etc., for doing complete justice in the cause. So you can resort to 142 for even, you see, it is an exercise of these powers for the purpose of enforcing the right of the people, the entire nation, under Articles 14 and 21. By virtue of the power under Article 32 read with 142. That was the origin of the Hawala case, that was the reason. I remember when we were dealing with that case, the American Supreme Court judges were in India, in Delhi, for a conference because we had biennial Indo-US exchange and Indo-British exchange. Justice Scalia, one of the most brilliant judges, but a very literal constructionist. Every day I would read in the newspaper as Advocate Nadkarni was saying, and the media would report the progress of the case. So one morning when we met, he told me, he said, Justice Verma, he was very sarcastic. He said, Justice Verma, what is that which you cannot do? I'm trying to think, what is that which you cannot do? I answered him with all seriousness. I said, Justice Scalia, I'll put it this way, it's not that what I cannot do or what I'm trying to do. I said, I have not yet come across a roadblock where I find that there is something which I cannot do and I should not do. And the reason is obvious. The reason is, we have Article 32. You don't have a corresponding provision in the American Constitution. For 1/3 of our population, you have 3 times the land mass. You start on a 90 ml advantage. The amount of food which you throw in the dustbin would be enough if collected to feed the teeming millions here. I said the first time when I went to America, I was very uncomfortable. When we in the hotel were having the first meal, I said, when he brought the soup, there were 4 of us, I, my wife, and Justice Ahmadi and his wife. When he brought the soup, I thought the quantity supplied for one of us was enough for all 4 of us. And in addition, there were other dishes ordered, so I called the waiter. I said, will you kindly, modify the order? So he just didn't bother. And he said, why, what's your problem? I said, our problem is we don't throw food. Well, even then he didn't show any interest. Then I said, all right, if you can't reduce the bill, don't do it. But we don't like seeing food being thrown. So he just ignored us, kept on piling food on the table. By the time the entire food came, we just couldn't eat because the sight was, and all that was thrown. I said, if the person in America who lives on dole, Social Security, is better off than an Indian who has to work for his livelihood. See, I said, if this is the difference, I am not surprised at your reaction. But then I look at it this way. The framers of the Constitution, when they made these provisions, imposed a very high duty on us to protect the fundamental rights even of a single individual if the violation came to our life. Now here it is the rights of the entire nation which are being violated. If I can't act and exercise this power, I am not fit to be where I am sitting. You see, I think this is the kind of, if we stop thinking of what we call our power and look at it as our constitutional obligation, I think the perception would change. It all depends on how you look at these provisions. Whether you look at them as elevating your status, well, then the perception would be different, the reaction would be different. If you look at them as a duty imposed upon you, well, you see, then and that is what was expected of you. I remember in 1997 when I was in office, there was SARC Chief Justices and Common Chief Justices Conference in Karachi, and to go there. Mr. Alapus, the law minister, I believe there at that time. Now you would recall Mr. Sajjad Ali Shah was the Chief Justice at that time, and Nawaz Sharif was the Prime Minister. They were daggers drawn, and every day there was some skirmish between the two of them. And to my great embarrassment, Sajjad Ali Shah was relying on my judgments about the judiciary to fight with the Prime Minister there. So the bar, they were inviting me in Lahore and Karachi for quite some time, but I avoided going, not merely because of my apathy to travel, but otherwise also because of the atmosphere. So when this conference came, Chief Justice Conference, it was, something official I had to. So I told the Prime Minister that on some pretext I will avoid, because in this mood of the people there, and these people I don't want to. He said, no, it's very important for our bilateral relations, so please go. When I went there, I'm mentioning these incidents only to indicate how good governance requires, a proper understanding and conduct of all constitutional functionaries. When alone, you will have a well-oiled machinery which will produce the result. Otherwise, there will be skirmishes which end up in the people getting hurt. So, at the inauguration, the Prime Minister was there, the Chief Justice was there, and we, Chief Justice from the SAR countries, we were there. So, we were not supposed to speak other than the Chief Justice of Pakistan, who was the host, and the Prime Minister. But we were all seated on the dais. Now, one spoke, then the other spoke, and they were each one of them lambasted the other, and of course we were quietly watching and hearing. I didn't realize that very soon, something will happen which will put me in project me in a most uncomfortable position. So after Sajjad Ali Shah, the Chief Justice, had spoken, he said, now I request, they are very courteous people and people to people. He said, I request Bhai Sahib, so he was calling him Bhai Sahib. He said, I request Bhai Sahib, Chief Justice of India, to say a few words. Now I didn't know in this fight what had I to do. So anyway, I had to get up to say a few things. So I told him, I said, it's come as a surprise, and I don't think I'm supposed to say anything, but since I've been asked, I must say something, and I have only this thing to say. I'll just share with you, I said, the audience, one of my experiences, and leave it to you to draw your own inference of what I mean to say. And I narrated to them that episode with the Chief Justice of Rajasthan, Mr. Ardev Joshi. I told him. And I said, after that we had very good relations. I told him how the outcome, etc. And I sat down. I said, because my message was clear that the two of you are Krishna here was there in the audience. He told me, well, you have told them, but let's see how they behave. Now you saw what happened, because that's a part of history. They both continued to behave as they did. Not that they had to take any hint from me, but then even otherwise. And both came to grief. Sajjad Ali Shah was sacked, and Nawaz Sharif. So this is what happened. Who are suffering ultimately? The people of Pakistan. So you see, these are things, the broad basic principles which one has to apply. Now, you see, the question is, what is the role of judiciary in this thing under our constitution? Now, Article 37 says, which is in the beginning of Part 4, that these are principles, they are not enforceable, they are not justiciable, that is, but they are principles fundamentally in governance which have to be borne in mind by the state in making the laws. So, ordinarily, literally interpreted, it would mean judges don't make laws, of course. Now that myth is also exploded, but then it is supposed to be a mandate to the legislature. Okay? But then, who determines the meaning of the laws? The meaning of the laws is determined by the judiciary. Meaning of the laws and the constitution. Constitution is what the Supreme Court or the judiciary says it is. And therefore, the judiciary has to accept or read these provisions in the directive principles as a mandate to them that interpret the laws and the constitution consistent with the mandate to the state in Part 4 of the Constitution. It is acting on this basic premise that even in spite of an express provision in 37 that these are not justiciable, the Supreme Court has read the directive principles of state policy in the fundamental rights, more particularly in Articles 14 and 21, to enlarge their scope and thereby make them justiciable. I mean, this, in brief, is a significant role discharged. Now let us see in general what is supposed to be the role of the judiciary. I would like to begin by reminding you of what Alexander Hamilton said. That was in the 78th Federalist about the American judiciary. He described the US Supreme Court, that is the US judiciary, as the least dangerous branch. That's the expression he used. Least dangerous branch of the government. Why? Because it does not have the purse for which it has to depend on the legislature. The finances have to be, you see, voted by the legislature. And it does not have the sword. It can't implement its own orders. It has to depend on the executive. From that least dangerous branch, there has been a sea change. Even there. And the typical example was the election of President Bush. Well, it is well known and accepted that Bush did not become president by being voted into that office by the people. It is the Supreme Court which gifted the presidentship to him. See, Bush versus Al Gore. That is what one of the US Supreme Court judges on the bench himself said it. You see, now even there, without that expansive power which the Indian Supreme Court has in the Constitution of India, the US Supreme Court, you see, from the least dangerous branch, has come to even gifting the, you see, presidentship in this particular case. Not only that, you see, the book on, rather magnum opus on American Constitution is by Willis, Hugh Evander Willis. In the preface, he writes something which I would like to read out to you. The perception there also of the Indian. He writes about the judiciary in US, that the US Supreme Court. He said, and I quote, "It is easier to speak of the solar system without a sun than to speak of the American democracy without the Supreme Court. And that the constitutional rights, please mark these words, and that the constitutional rights of the American people were safe in the hands of their Supreme Court." Unquote. This is the source of the strength of judiciary, because it is seen as the custodian of the constitutional rights of the people, and ultimately the strength, the source of the strength are the people of the country. And here it is said so expressly. So it is this public faith in the judiciary which ultimately makes it, rather elevates it from the position of the least dangerous branch to certainly, if not the most, then certainly one of the strongest branches. I could hear repeatedly when I was in your court, whether in America, Australia, or England, anywhere, they said you are presiding over the most powerful court in the world. That is the perception of the Indian judiciary. You must have, see what you are reading every day and what is happening in the Supreme Court. You see, following that principle of continuing mandamus evolved in the Avala case, whether it's 2G spectrum or CWG or whatever, monitoring by the Supreme Court. Well, the Supreme Court, it's not that it is calling the shots, it is ensuring good governance. Wherever there is aberration, and the politicians can't ignore it. Why? Because the one thing which politicians would always dread is losing, you see, the support of the people. So, howsoever much they may try to say it is, and say it in a pejorative sense that it is judicial activism, but so long as the judicial interventions are in the right direction and are promoting public good, the public acclaim is its real strength, and therefore that is really the source of the power. So in order that the judiciary retains its credibility and its strength which it has gained for good reason, you must remember that the power is to be exercised only for public good. And therein comes in also the concept, and the requirement of judicial independence is one of the basic features of the Constitution. And the talk of judicial accountability these days, very rightly, is because judicial independence also, you see, depends on judicial accountability. Unless you are accountable with all that power, you are bound to lose credibility. And that is what the judiciary, therefore, has got to remember. Now, in India and in our constitution, there is a specific provision. Judicial review is a basic feature and therefore a part of the indestructible basic structure. And that is expressly provided, Article 13. Anything which is unconstitutional, the courts have to strike down the exercise of their judicial power. The Supreme Court's power under Article 32, 42, as I have said. The High Court under 226, 227. So this is expressly provided here. But see, in jurisdictions where it was not expressly provided, how it has grown and accepted. In America, it was Chief Justice Marshall in 1803 in Marbury versus Madison that the seed for judicial review was sown. But very often it is forgotten that 2 centuries prior to that, in 1608, it was Lord Coke in Dr. Bonham's case who really, judicial review, the power of judicial review started germinating in 1600 there, and that without any express constitutional provision. England doesn't even have a written constitution. Here you have express provisions more than one in giving that. So the role of the judiciary is no longer in doubt, and so far as India is concerned, it is expressly provided. How much difference it has made even in America here, of course. Now Brown's case, 1954, that was a clear case of what you may call judicial activism. See, later I will indicate that here in India judicial activism is not only under the Constitution. According to me, you see, it was pre-Constitution by some of the greatest judges that we have had. Just to give an example here to connect it directly, I have always considered Justice Vivian Bose as one of the greatest judges ever. Of course, I didn't have the privilege to, be in the judiciary even as a lawyer when he retired in 1955, because I joined after that. But you see, his judgments, some of them, I mean, they are mind-boggling. How could, and mind you, pre-Constitution. Constitution came into force in 1950. Now, he, in 1949, in pre-Constitution, when, of course, you see, there was no question of even thinking in those terms, Justice Vivian Bose held in the case of a forest officer, the question was whether, you see, a forest officer's tortuous act could give rise to the vicarious liability of the state for that tortuous act. The argument was the standard defense of immunity of the crown, that is, you see, sovereign immunity. Vivian Bose said, he said, forest is not a primary state function, it is a commercial activity. And therefore, the forest officer of the government is engaged not in a sovereign primary function, but in a commercial activity which anyone else can also perform. So no defense of sovereign immunity. He said it in 1949 in a case which incidentally in All India Reporter it is reported in 52, but I have checked up. In ILR, Indian Law Report says 1949, it is a case of 1949. Everyone thinks that the concept of reasonable, just and fair, or the rule of non-arbitrariness, as embedded in Article 14, right to equality, is Maneka Gandhi 1976 by Bhagwati. It's not so. At a time when the Supreme Court was so conservative in the beginning, and you had A.K. Gopalan's case, where in Article 21 they said any law is good enough, and it need not satisfy the test of fairness. Justice Vivian Bose, in a concurring judgment in 1952, Anwar Ali Sarkar's case, he said anything to be equal has to be reasonable, just and fair. These are the three words which, you see, people think originated from Maneka Gandhi. No, it is Vivian Bose. Now look at the vision. So judicial activism is not such. So none of us are pioneers in judicial activism. If any one of us think that we have done that, well, I think we are being too presumptuous. It is these great judges who did that. Now, when the states merged, princely states, questions arose about service contracts and other contracts, and the defense plea was act of the state, a legal principle of private international law, or conflict of laws, as they said. Vivian Bose said in Viren Singh's case in 1954, there can be no act of the state after the constitution was framed, because act of the state is not available against your own citizens. So on 26 January 1950, when the Indian Constitution came into force, everyone was equal citizen of India. How can you take a plea that this man